Yes.
Well, as I said, we'd finished with Hirtie. You've already been taken to this, but I also see that you received a note from.
Thank you very much. Thank you.
So just going to.
And I think Mr. Hawking might also have sent something, but I'm not quite sure what that is.
There's no need for me to trouble you with it at all at this point.
Thank you.
I think just because Lord Thomas's encouragement to tribunals to follow the balance sheet approach is in Hirtie. As you saw, 289 to 290, you don't need to go back to it. I'd say, and you already have this point, that all he says is this is one way of structuring a judgment.
Yes.
It's an encouragement to do it. In my own experience, since if I'm going to give evidence as
I did invite you.
is not that this is routinely used in deportation cases, but it might well be that using a balance sheet approach makes it less likely that you will be appealed, because it may be a good way of setting out reasoning. And I think it will be. Lord Thomas didn't purport to set out a mandatory requirement, and no one else agreed with him anyway. And I would discourage any suggestion from your lordships that this should be taken as a mandatory approach. If it's a matter really for the tribunal, if the Upper Tribunal thought that it should give guidance about how deportation decisions should be structured, then it might do that.
Thank you.
Yeah. So then I'm on. Does Hirtie remain good law? I'd like to refer to three post-Hirtie cases which continue to rely on it. They are Akinyemi, Unuane, and then HA Iraq itself.
What's the middle one, Akinyemi? What's the middle one? What's the name?
We're all pronouncing it different. It's Unuane.
Oh, in the ECHR, yes.
It's the ECHR one. I may be totally wrong. I'm just giving every vowel its worth.
It's full weight, yeah.
Yes. So Akinyemi, and I wonder if I think I've lost my copy. So this is the case, and I'll deal with. I have another sub.
Where do we find it?
My lord, you don't find. I'm afraid this is the 54th authority, which was handed out separately this morning. So this is the case about a person who was born in the UK, who would have been entitled for most of his life to apply for British nationality, didn't, started offending. It's a serious offender case, because he I don't remember. Yes, his most serious. He was convicted of causing death by dangerous driving and got 4 years imprisonment, in among a number of other offences. But that was the one that brought him within the serious category. He hadn't been lawfully in the UK all his life. He'd just not been unlawfully in the UK because he wasn't removable. So he couldn't bring himself within the exception. We say he's an example of the kind of case which can succeed. He's not allowed outright, but this court clearly thought this was a case which was capable of succeeding. Remitted it twice, and so this is a case where there isn't any need there doesn't have to be an exception around which to cluster the compelling circumstances. There isn't an exception which could be met here. Nonetheless, this was a case that was capable of succeeding. Paragraph 50 is the paragraph where the court concludes that the public interest, even in a deportation case...
Sorry, which paragraph?
My lord, sorry, paragraph 50.
50, thank you.
That even, therefore, in a deportation case, and even in a case where there were a serious offending case, that the public interest is flexible or movable and not fixed. That's paragraph 50. So whatever the 2002 Act does, it doesn't create a fixed interest. It creates a movable interest. And en route to that, this court...
There's some difficulty with that in the light of the words of the Act, because the Act says, and the other Act says, the public interest lies in deportation. I accept it may go up and be stronger than just because he's a foreign criminal, because it's serious offending, or because of the 177B. And I just wonder whether other factors, such as the fact that he's been here in the country for a very long time, is something that goes to the very compelling circumstances balance. In a way, it may not matter, but that's where it seems to fit better.
Well, my lord, there are two ways of looking at it. One of it is that all of these factors, everything else other than the so there is a fixed public interest or fixed minimum public interest, which, as my lord says, could go up if you're an axe murderer, unrehabilitated axe murderer. That's one side of the balance, and the very compelling circumstances are everything both going to the public interest, either raising or lowering it, and going to the strength of the family or private life, either raising or lowering it. So one model is, on one hand, you've got your fixed minimum public interest, and then on the other hand, you've got everything else. And the other way of looking at it, which seems to be the way that it is the way in my submission that this court looks at in Akinyemi, is that you start with Parliament's decision about the weight to be attached to the public interest, but then that's only a starting point. There is a degree of flexibility built into it, and the reason so that becomes a more conventional balancing exercise, where it's the outcome which has to be very compelling, or it's when you're conducting the balancing exercise, you have to end up at something which is very compelling. If it's, we'll put it a different way, a decision will be proportionate if the consequences of it are not unjustifiably harsh, but that test will only be met by very compelling circumstances. We can see that the reason we know that the court in Akinyemi took the second approach is that what the court found to be wrong in the Upper Tribunal's decision was that it didn't bring in so the factor which it said was relevant to the public interest was that someone had been born in the UK and spent all his life here. And what was said to be wrong with the Upper Tribunal, paragraph 53, is that the Upper Tribunal didn't deal with that issue in the context of assessing the weight to be attached to the public interest, but brought it in somewhere else. So it seems from Akinyemi that what the court thought should have been done is that you bring this in on the public interest side of the balance. If there's a factor which goes to public interest, it should go in there, rather than in a separate assessment of very compelling circumstances. It's not surprising, I respectfully submit, that the courts have struggled with this, because where on the one hand it suggested that what always needs to be done is a proportionality exercise, or always needs to be conducted as a proportionality exercise, and therefore always a balancing exercise. And on the other hand, you have a statute which seems to impose a single threshold test. It's quite hard to bring those two together.
I'm very sorry. I can't understand the complexity of the way you're expressing it. The statute says there are two classes of foreign criminals, one under 4 years and one 4 years and more. And if you're under 4 years, then you've got to go unless you can bring yourself within an exception. If you can't bring yourself in exception, you're in the same position as a 4-year plus person. You've got to show very... The public interest, and then the statute says expressly that the more serious the crime, the more serious the this and that. But whichever way you look at it, you start with the offending, and then you've got to look at the countervailing factors. Why is it more complicated than that?
My lord, I'm not...
And if you say it isn't, you shall be my favourite advocate of the year.
Well, unfortunately, I'm not sure I can say it. I do think that we get to the same place, and I'm not sure that it's net. But the reason why it's more complicated is that the same. On the one hand, you have that approach. On the other hand, you have the Supreme Court in HA Iraq talking about a full proportionality exercise, and those two don't easily sit together. That's why it's complicated.
If you look at 117C, just look at the words of the Act. Actually, it says, one, the deportation is in the public interest.
Yeah.
Then it's more serious. The greater is the public interest if it's more serious offending. And then if you look at 3, it says, in the case of a foreign criminal, the public interest requires deportation. It's not the public interest will go up or down. The public interest will require it. unless it's one of the exceptions. And then you've got exception 6. And there's exception 6 says the public interest requires it, unless there are very compelling circumstances. So I can see how you can increase it, but I can't see how you can say you get to a situation where the public interest doesn't require deportation, because that's what it says. What it really means is even though there's still a public interest in deporting, he's still a foreign criminal. But there are very compelling circumstances. So if it's to do with the length of time he spent here, notwithstanding the illegalities, the Windrush generation is frankly the fault of the Home Office, then you take that into account. There are very compelling circumstances because his situation is not reprehensible. He's like somebody who would have been British if only the Home Office would have done it.
But the problem then, my lord, yes, that's the outcome we all get to. The difficulty is in the word requires, isn't it? Because we know that the public interest doesn't require deportation. It doesn't.
The public interest does require it unless certain circumstances apply. But they are the circumstances that apply. Doesn't mean that the public interest has been reduced and therefore doesn't require it, does it?
Well, it means that it's outweighed. It doesn't mean it's switched off either. So,
well, but it goes into the balance. I really don't think it matters. Actually.
Well, so if my answer, if this would make, I doubt it'll make me your favourite advocate, my lord. But I agree that I don't think it matters. But in terms of where you get to at the end, what will matter is if it has the consequence that, for instance, certain factors are discounted from consideration entirely, and that's what I'll come on to, provided that it's accepted that all factors which are potentially relevant to a proportionality exercise have to be considered at some stage, then it probably isn't going to make any difference.
Because otherwise you would say that the public interest in the deportation of somebody who's been sentenced to 25 years for a particularly heinous murder would be exactly the same as somebody who'd been sentenced for less than 4 years, and there must be some weight attached to the nature of their crime, the frequency, etc.
Yes. And their conduct was there's no so that must be common ground between all of us, that the weight can go up or down depending on the seriousness.
The weight can certainly go up, but what that means is if you're looking at very compelling circumstances to outweigh it, if you've got I'm obsessed with axe murderers, if you've got the serial killer, then that's really serious offending. So the public interest was always he should go when he killed his first one. But by the time he's on to number 10, it's much greater. And compelling circumstances would have to be very, 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 very compelling to say an axe murderer should be allowed on the streets of Birmingham.
But my lord, there's no dispute about that. But the difficulty is just that it follows on from Akinyemi. In my submission, that judgment can't be read any differently. That it's also possible. It's also possible for the public interest to reduce. This is a person.
When you say reduce, not to the extent that it isn't in the public interest, that you start with the public interest requires deportation.
Yeah.
So the nature and strength of the public interest will depend on the particular circumstances of the case. But I think what my lord is saying, it doesn't mean you get to the stage you reduce it to the extent of there being no public interest, because otherwise we wouldn't be there at all.
Well, it's drafting which is made to sound more mandatory than it really is. It's the same as calling the automatic deportation automatic. Deportations weren't automatic; they're not automatic, and it's slightly public facing in my respectful submission.
Full proportionality of primary consideration. We must be so careful with labels.
Yeah.
Okay. Thank you. Yes.
Sorry, did I mislabel?
No, you didn't at all.
My obsession with labels.
Yes, okay. But I do. So my submission would be that the danger is that if too much. The reason why the term full proportionality is used is because it makes clear that all of the Strasbourg factors need to be factored in somewhere, and all of the other possible factors, any other relevant factors, as Strasbourg's a non-exhaustive list. Ultimately, how you get to the point, whether you conduct the kind of balancing exercise which we say is envisaged by this court in Akinyemi, or whether you have a fixed threshold, but then you weigh things.
Just cutting to chase, and leaving aside all these cases which seem to be, I assume, going to say the same thing, if you're dealing with the facts of this appeal, and we're only looking at one of the three factors, which is the child, Exception 2 summarises the circumstances in which it will outweigh deportation for a medium offender. I know he's serious, stick with me. Assume he's a qualifying child, for one reason or other. What exception 2 is looking at is there a genuine subsisting relationship? And if so, is it going to be unduly harsh on the child to remove it? That's what that is looking at. On the facts of this case, and the wording of the Act, if you're relying on that factor alone, the relationship between the child and the foreign criminal, and there is no subsisting relationship, so there can be no undue harshness in separating them. That's the end, isn't it? There is no balancing factor.
No, my lord, so
that's what would help me is how this Heshamali Akinyemi applies to in a situation where you're supposed to have factors over and above, and it seems to be less, and we haven't addressed that yet.
So I'm going to come on. So imagine a case again. You're hypothesising a medium offender. Let's hypothesise someone who. No, let's go on the facts.
Take the facts of this case.
Yeah, I'll take the facts of this case.
What we're actually dealing with.
Yes. Well, we are dealing with
a serious offender who's had no relationship with the child for 6 years.
No.
And if we're
my lord,
dealing with that fact,
can I hypothesise that he's a medium offender? Just as you did, just to avoid the.
Okay, go on.
Well, no. So. There are two possibilities. One of which is that when you're looking at the. I was planning on coming on to this briefly.
Should we leave it?
Leave it until you want
Why don't you finish?
Got to address that
of course, you have to address that at some stage. Can you continue?
I will continue.
Because I'm worried about timing again.
My submission will be that this either falls within the kind of case which is covered by exception 2, because it's about the potential of family life between a father and a child who are separated, and so this is one of the cases in which the exception is not met, just as it might not be met if the child was not British. It's not met because there's not presently a subsisting relationship, but nonetheless it is a case of that type, and therefore it's relevant when you assess things humanly.
What's the factor over and above genuine subsisting relationship that's relied on?
There might be many. There might be significant impact on the father of being separated from his dad. It's not just about the best interest of the child. There might be his mental ill health. There might be any other cumulative factor. All I'm saying is that there are two answers. One is that this is a case of the type which is covered by exception 2, but it doesn't fall within exception 2 because there's no subsisting relationship. And the other way is that this is a case which completely falls outside. It's the equivalent of what Lord Justice Bean referred to, the relationship between a parent and their adult child, and he saw that as being a case which falls completely outside an exception. I could give other examples, and one could think of other examples, relationships between adult family members. Those are examples given in Yeltsin, and that the very compelling circumstances test has to be capable of encompassing cases which fall completely outside either exception, because otherwise this statutory framework will be incompatible with Article 8. It's only because it's sufficiently flexible that it will allow cases that fall outside the exceptions to be dealt with cumulatively, and the ultimate question will be, is the cumulative weight of these private and family life considerations sufficient to amount to very compelling circumstances?
Sufficient to outweigh
the very high public interest, my lord. Exactly, yes.
Thank you.
And this structure has to be read in that way, because otherwise there are going to be, in the same way as in NA, Pakistan, which I'll come to in a moment, the statute was read down to prevent it from excluding from consideration a tranche of cases which would, where that exclusion would give rise to a tranche of incompatible decisions.
Just very quickly, just so you know what's troubling me.
Yeah.
The problem is that when you're dealing with genuine subsisting relationships, and the sorts of things that outweigh public interest in deportation, Parliament has weighted them and has said genuine subsisting relationships, yes, where it's unduly hard to separate them. So I don't see how you're saying this is something outside it. When Parliament has said you've got to have that as a minimum, there needs to be something more than that, not less than that. That's
So-
where I'm still at, you see. Is the
Yeah,
problem.
my lord, if that's right, and if tribunals are restricted from considering any relationship which is not presently genuine and subsisting, then it will then the Secretary of State and the courts will breach Article 8 as a result of the statute, and the statute
Why?
won't
Because the
survive.
weight to be attached, there's nothing else on. He's relying on
So-
a future relationship, and Parliament says no, that's not going to be good enough.
So my lords may remember the case of Pawandeep Singh and the ECO. It's a case from 2004-2005. I'm sorry, it's not in the bill because I hadn't foreseen this. It's Lord Justice Dyson and I think he was still Mr. Justice Mumby sitting in the Court of Appeal. It was a case about a prospective adoptive child who was seeking to join his relatives. I think they were an aunt and uncle from recollection. I can get but they'd not established a relationship. It was prospective outside the rules adoption, and in I think paragraph 37 of that judgment, the court concluded that provided there was some basis for family life, then the prospect of family life was relevant to an assessment of whether family life was established and therefore to the level of interference. So that's what the law is. That is a matter of the substance of Article 8, that relationship, a prospective relationship between a to-be-adopted child and the to-be-adopted parents is protected, even though there's not a subsisting relationship on one view.
Well,
And there are two ways of... My lord, sorry, yes.
no, it's all right. I mean, you could give the example of a child who has not yet been born. It would be difficult to say that somebody has a genuine subsisting relationship with a child that hasn't been born. I suppose you might say that there is a relationship. You might not.
There's a complexity as to whether that child can be has a protected...
But you're saying there are circumstances in which there might not be a current subsisting and genuine relationship, but looking at the facts of the case, either there could be something that would make it unduly harsh for the child, and/or there are other circumstances which the court would need to take into account. Can we move on? Because I think you're dealing with that.
Well, it is to do with the fact. So the way I put that, I will move on, my lord. But the way I'd ask the court to look, I'd suggest that the facts of this case should be looked at is that you're looking at the prospects of it. So it's a relationship. There's no doubt that this is on the findings that this is a relation. This is a father and son who had a relationship, and he was a good dad for the short period of time before he and the partner and the child's mum separated, and then he went to prison for loads of years. And for whatever reasons, the relationship has broken down.
Thank you.
The family court would look at the best interests and the prospects of, and so on. But so, let me go back to. Sorry, I was in Akinyemi, and I think the point I wanted to make there at the moment, I'm still on the submission that Hesham Ali remains good law. So simply, you see that en route to its conclusion, and its conclusion is that the public interest is flexible. This court rely on this is a case dealing with Part 5A of the 2002 Act. You see that from paragraph 46.
Yes.
En route to it, you see that the court is treating Hesham Ali, the judgment, Lord Reed's judgment in Hesham Ali, as governing, and in fact is also relying on some sections of Lord Care's dissenting judgment, just on the basis that he was expressing in some parts of his judgment matters with which weren't disagreed with. And so one of the issues which this court approving a persuasive judgment of Lord Care, paragraph 49, the strength of the public interest must depend on such matters as the nature and seriousness of the crime, no dispute about that, the risk of reoffending and the success of rehabilitation. Well, the success of rehabilitation, just so in principle, can only reduce the public interest, successful rehabilitation. So so the paragraph 50, which is the paragraph of Hesham Ali, which I took you to as representing what we say is a full proportionality assessment, is here relied on at paragraph 48 back in Yemi, and then the the shifting weight in public interest is relied on at 49, and it's all en route. It's all en route to the ratio, which is at 50. It's the Supreme Court which has clearly identified that the strength of public interest is flexible and movable and not a fixed interest. So that's one indication that Hesham we say, remains good law after the statute. The second is Unoane, and that's the final tab in the main authorities bundle, and it's starting at page 954. And you've already been taken here by, I think, possibly two of Moylan and friends, so I don't want to spend very long in it.
Sorry, which page?
I'm sorry, it's sorry, which page am I starting to read from?
Can you just remind us what the facts were, rather than just take us through what is it about? What was the claim, the issue? He's a Nigerian national.
So it's
He had a
954.
right to residence. He had 3 children.
5 years and
All
6 months.
British nationals.
Yeah, so he's a serious
5
offender.
years and 6 months, yes.
He has deportation made against him, his partner, and 2 of his children, and they appeal.
What page are you on?
My lord, sorry, it's 954. It's the beginning of the holding.
Thank you.
At the beginning of, sorry, the summary.
There's a medical condition and a need for surgery for somebody. Yeah.
My lord, yes. But he had not succeeded.
Yes, and he could be expected to leave, yes. Was he the child, indeed? Was he the foreign criminal?
No, he was the foreign criminal.
Right, okay.
And-
He
and-
needed
My lord, yes, but this case doesn't. I understand why the context is relevant. What's relevant about the context is that it's a case about.
No, he is the child, actually. They said it's unreasonable to split the siblings, yes.
Well, so the applicant is the Nigerian national who was born in 1963. That's page 957, paragraph 2. But of course, the interests of the other family members were considered in the normal way. But just, my lord, Strasbourg doesn't. Your lordships know this. Strasbourg doesn't create factual precedent. It's relevant to seeing.
No, do you understand what the facts are in order to understand?
My lord, absolutely yes.
Yes. You can't take something they said and apply to totally different facts and assume it would be the same.
Well, the passages I'm planning to take you to are at quite a high level of abstraction from the fact. This is the Strasbourg court considering whether, and it's a judgment on which Judge Eicher sat,
Yeah.
and it's a large part of the judgment is devoted to considering whether the rules themselves and the statute were incompatible with Article 8.
And were they?
No, and that's what it said. They weren't. The Strasbourg court then went on to say they'd not been applied lawfully to the case of this applicant, and so he succeeded. But I'm not relying on that. I'm relying on the part and what's said about the rules. And the first point is simply that. So you see that it's the usual part of a Strasbourg judgment which goes through the relevant legal framework, starting on page 960, and it's everything we've gone through today.
Yes.
BCA we haven't. That's section 55, the immigration rules. The 2002 Act you see on page 962, Part 5A, came into force in 2014. And then the further immigration rules amended in line with the statute. And then judicial interpretation, page 964, again, the same cases we've looked at, MF Nigeria, NA Pakistan, I'll take this in a moment, and then Hesham Ali. And but the bulk of the considerations of domestic law about the statutory and rule-based regime is the section on Hesham Ali. That's on page 967 through to 971, and then paragraph 50 you've got Agyarko as well, which as I said, that's the case which was heard by either entirely or largely the same constitution of the Supreme Court a non-deportation case at the same time or at almost the same time as Hesham. Then we go on to alleged violation. '57, acknowledge that the Supreme Court had now endorsed the balance sheet approach. I just draw your attention to that.
Thank you. Yes.
This is the applicant. And then 58, this is paragraph 58, top of page 973. You see the allegation is made that the domestic, pursuant to the statute and the rules that you've seen, the domestic decision was unable to adjust the weight of the public interest according to the nature and seriousness of the crimes involved. So that's the allegation. If you're not going to be able to adjust the weight, you're going to end up with an approach which is incompatible with the difficult evaluative exercise required by Article 8 of the Convention of 58. And relied on Lord Kerr's dissent, 59. And then what's interesting is the government's response. So this is the government in court in Strasbourg saying what the rules and statute are intended to do. And you see that from paragraph 61 onwards. 63, at the top of page 974, the framework does not prevent the domestic authorities from considering the criteria in Boulty, Finner and Maslow. Those are the three cases that Lord Reid referred to in Hesham, or any other factors upon which an individual wished to rely. That's the government's view of the framework. Rather, it ensured that the domestic decision maker appreciated that in a case of serious offending, the family and or private life factors relied upon would need to be commensurately weighty before the striking of a fair balance. So before the striking of a fair balance precluded expulsion. And then all factors to be taken into account. Domestic courts have repeatedly held that the provisions had to be interpreted and applied so as to produce a result. So just stopping there, what the Secretary of State is not saying is we can do what we want because it falls within our margin of appreciation. It's saying we're trying to do what Strasbourg requires of us. 64, the very compelling circumstances did not provide a comprehensive list of the factors to be taken into account. On the contrary, all relevant facts, including reform and rehabilitation, were to be looked at cumulatively and placed in the balance. The balance, we say again, it has to be a proportionality balance, a full proportionality exercise. The domestic courts have made clear that the tribunal had to continue to strike the proportionality balance by applying the principles and then relying on Hesham for that. And then again referring to balance sheet approach, and my submission simply that the technical exercise of the balance sheet approach is not a necessary way of conducting a balancing exercise. You can do it without having to do a balance sheet approach, and that's the other courts, as my lord has pointed out, are quite capable of doing it without adopting a balance sheet approach. And then even where this is 65, even where an individual did not succeed on any of the specific statutory domestic exceptions to deportation. So, for example, a person who doesn't have a genuine subsisting relationship with a child, I would say, but only has the prospect of one, the tribunal nevertheless had to ultimately consider whether deportation would be disproportionate, balancing exercise. It therefore followed that a full proportionality balancing exercise always had to be conducted, preferably by way of a balance sheet exercise. Not always, but preferably, and even where the unduly harsh test was not satisfied, and we're in the context, and my lord's right to have gone to we're in a family case, that's why the court keeps going back to unduly harsh. An individual could still succeed on Article 8 grounds once all the facts in his or her favour were weighed against the public interest in deportation, having regard to the nature and severity of the offending on the basis of the guiding principle. And then, so that's the government's view of its own law in a case which is about the compatibility of those legal provisions with Article 8 in Strasbourg. And we say that assessment is spot on with respect, and it's consistent with what's said in Hesham and it's consistent with what's subsequently said in
Was it endorsed by the court?
My lord, sorry.
Was it endorsed by the court?
Yes, I'll come to it, yeah. Can I just... Well, that's how I reckon. Before I say that, if my lord looks, if your lordships look at paragraphs 81 through to 83, well, 80 you see again. So this is coming back to it. The applicant argues that the tribunal was precluded by the immigration rules from conducting such an assessment, and relied on Lord Care's observation, and this was where he dissented, that wouldn't be compatible with Article 8. And then court. That being said, the domestic courts have confirmed, and the government has reiterated before this court, and then a summary of everything that you've just been taken to. And then 82, Hesham Ali. So that's 81, what the government said to court. 82, what Hesham Ali says about the exercise. And then 83, in light of the foregoing. So, my lord, I would read that as being accepting that and endorsing it, because in light of the foregoing, the court does not consider that the immigration rules necessarily preclude the domestic courts and tribunals from employing the Bull-Teeth criteria for the purposes of assessing that an expulsion measure was necessary and proportionate. Well, just while you're on that page, I think you were taken to this, but just in case you weren't on page, I think my own friend Mr. Hawkins took you there, but paragraph 78, page 977, that the respective weight to be attached to different cases will inevitably vary according to the specific circumstances of each case. And I would add, although it's not here, but that some of the factors set out in the Bull-Teeth criteria will have no relevance at all in particular cases. The example is the Maslov case, which was the Bulgarian national who arrived in Austria when he was 6 and he was 19 when he was deported from Austria. And in giving the guidance, in giving its judgment in Maslov, I'm sorry, we don't have that authority here. The Strasbourg court, the Grand Chamber said, in that kind of case, which was about a young person who spent most or all of his life in a host country, the relevant factors are, and it just picks out from the list of Bull-Teeth factors, the not very many which are relevant to a person who hasn't founded a family, doesn't have a wife. So the question of whether the fact that the partner was aware of the criminality before they met, that falls away.
I'm just trying to understand the finding of 89, and you need to understand the fact. Was it the case that all of them, the foreign criminal, the partner and the children were going to be deported?
Yes.
I see, and they decided to allow the appeal of the mother and the 3 children, but not the appeal of the father, and they then say the partner and the children needed him. That was particularly acute to the case of D on account of his medical condition, and it is in residence of the children for him to remain in the UK. So that deals with that, yes.
I think it was 2 of the 3 children. I think one of the children was British and the other 2. So one of the children wasn't deportable.
But to do, they were going to deport all the non-British ones.
That's right, yes.
Yeah.
Yes, no, you can see why the court could say this statutory and rule-based regime is compatible, but in this case it's gone wrong. In this case, because of the factors to do with that case. That's how this is. That's why. So they lose on their macro point, but they win on the facts of their case. So yeah, thank you. My learned friend asks me to take you to on page 978 to paragraph 84 to see the Upper Tribunal's reasoning. So that's right. So in fact, the Upper Tribunal had, on the face of it, taken precisely the approach which the applicants complained would be the outcome of the regime, which was to treat it as inflexible. So on the particular, so what Strasbourg says is, we agree with the government's submission about how this regime is meant to work. The court applied a more restricted or more inflexible approach. Didn't understand there to be flexibility built in, and as a consequence, reached a conclusion which was as a consequence didn't conduct. So didn't. didn't conduct an adequate investigation into the Article 8 claims, and therefore Strasbourg was able to conduct the investigation itself. My Lord, I said there were 3 cases that that I relied on to show that Heshmali remains governing. The third one is HA, Iraq itself. You've been taking to this a lot, so I'm going to try and avoid spending too much time on this. It's at tab 27, page 452. Sorry. Yes. So the first thing, just I think possibly slightly to correct a submission that I understood to be made by Moylan from Mr. Malik yesterday. The core issue which had to be decided in HA Iraq was the question of what undue the correct approach to the undue harshness test. And you see that from page 457, paragraph 6. That's a principal legal issue. And the Supreme Court had brought together, for the purposes of the HA judgment, appellants whose cases had been heard in the HA Iraq case here, in this court, but also the appellant in the AA Nigeria case. And that's, I'm not going to ask you to look at any of it, but it's in the bundle at page 385. So sorry, I've lost the sheet that has the tabs on.
23.
Sorry.
23.
23, I'm grateful, thank you. You don't need to look it up, but the important thing was that AA Nigeria was a serious criminality case. The others, the HA Iraq and the linked cases had been RA, I think, had been medium cases. And as a result of that, having decided the question of what undue harsh mean, or how the unduly harsh test should be determined, the Supreme Court went on to give guidance about very compelling circumstances. I'm just going to try and make 3 points. One is that, again, HA Iraq, at the crucial part of its judgment about very compelling circumstances, about serious offenders, goes back to the core passages in HA Iraq. You see that in Heshmali. Can I just say that a complication with this is that Heshmali was known as HA Iraq itself until it was promulgated. So if you at page 467, paragraph 49, you see that when deciding on the correct approach to the very compelling circumstances test, the Supreme Court in HA Iraq looks at Heshmali, and it does so again in paragraph 51, top of page 469, admittedly for the specific point of about the relevance of Strasbourg factors, and then you'll see that Unwane is reapproved, or it's reapproved.
So I'm not with you. I was just reading 47, which affirms the decision saying, in conducting the assessment, the end of B, you're required to consider the basis that the public interest requires deportation unless there are very compelling circumstances, over and above those described in exception 1, 2. And where are you going after that?
My Lord, sorry, is that, are you, no, so that's Lord Justice Underhill's summary, yes. So I was going to 49, which is
Heshmali, yes.
Heshmali. So it's the Heshmali approach to, or description of the role of the tribunal being relied upon post 2002 Act by the Supreme Court in HA Iraq, and then again for the approach to Strasbourg authorities.
So I'm just following through. Then it refers to Heshmali. Then it goes on it comes back to exceptions 1 and 2
Yes.
and explains how those should be worked. So what am I getting out of this at the
So
moment?
you get at the moment you're getting the very perhaps that you're just getting the point that the court, the Supreme Court in HA Iraq dealing with the Act does not have any difficulty with relying upon the approach, the pre-Act approach in Hashemali.
Well, that's what I'm trying to. I've read 47, I've seen 49, I've seen 50, which talks about how those sectors apply, and I've got 51, which says when considering whether there are very compelling circumstances over and above exceptions 1 and 2, all the relevant circumstances of the case will be considered.
My lord, so I was going to come on next to the question: what do you do? The question I posed at the start, which is it necessary to decide exception 1 or 2 before you go on to very compelling circumstances? And that's what the court is looking at in paragraph 50.
And then it goes on to say the weight to be given to the factors. I mean, it sets out the factors, but it says the weight to be given to them can be done by legislation. And for most of the factors that are listed, the weight is given. For some of them, they don't appear.
Well,
I mean, the last one, the solidity of social, cultural and family ties, that comes into the exception.
well, no, the weight isn't given though, my lord. I'm sorry, but the weight is, if someone says I rely on I've been here for 10 years, nothing in the statute says no weight can be given to that. And if the statute said that, that would be wrong.
The statute doesn't deal with all of them, but a lot of them are dealt with in 2 exceptions.
Well, but the length of residence in the country is a good example because it is dealt with in the exceptions, but not exhaustively. The section. So if I'm relying on private life, just by way of example, if I'm relying on private life, then one factor which is relevant to my private life is how long have I been in the UK. The Secretary of State, so that's the second of the Vulti-Una factors, page 469, second bullet point. The Secretary of State recognises that that's relevant to stay by introducing into the statute, into both the rules and the statute, provisions about the minimum length of stay, which can bring you within the private life exception. So the Secretary of State has said, provided that you are a medium offender and you've got that length of stay, and provided you meet the other 2 requirements of private life, then we don't need to look any further. You just we switch off your public interest outweighed. It doesn't say anything about the relevance of me having actually been in the UK for double the length of time, which would bring me within the rule. That's the example that's been given throughout, and I think you've been taken to the examples in NA Pakistan, someone who came here when he was 6 and is still here when he's 80. It doesn't say anything about the additional weight which would be added to that. It doesn't say anything about the weight that might be attached to my residence in the UK if not all of it is lawful. It simply says you won't meet the exception. It doesn't say therefore we disregard it, therefore it carries no weight. It doesn't say it doesn't tell me.
But if you don't meet those, if you're a medium offender and don't meet those, you've still got 117C6.
Yes, and if
It's
you're
got to be
serious,
over and above. If you haven't been here lawfully, or if you haven't integrated, or if you haven't been here for most of your life, then normally if that's the only factor you're relying on, that's not enough. You've got to have something more.
but it's not saying the weight to be taken. But I accept that the statute is saying if that were the only factor that I was relying on, my length of residence in the UK, and I fall short and I'm a near miss, then that's tough. But it doesn't say that's not going to be the situation which arises in most cases. Most cases are about cumulative factors, a private life factor, a family life factor, and so on. The statute does not tell me the weight that I should attach in those circumstances to my length of residence. It doesn't tell me the weight I should attach to, for example, and this is a situation which arose in a case where I was before my Lord Stuart-Smith. It doesn't say what weight should I attach to the fact that I've got 3 children, not 1. It leaves that to the judgment of and as my Lord concluded, it leaves that to the judgment of the tribunal, which will have to decide whether to attach greater weight to the fact that there are 3 children attached to my removal. It doesn't tell anyone how much weight to attach. It doesn't determine the amount of weight. What it does is it just says there is a threshold, and if you're above that threshold, we'll take that into account, and potentially it will disapply.
If you meet the requirements, you're in. If you don't meet the requirements, because you haven't been here for most of your life, or you're not integrated, you're out unless there's some very compelling circumstances
Yeah.
over and above that.
But the moment
Are you saying that you don't do that, or you do that first if you like, but then you take a blank sheet of paper and say, right, forget all that now, full proportionality assessment, been here 20 years, okay, it's unlawful, but we think it's not the end of the world. There is public interest in crime, but he's gone to a couple of rehabilitation courses and it looks as if he's going to get a job. So they do all of that again, either instead of or in addition to working through the statutory framework.
But the statutory framework, my lord, I'm not sure that I understand the statute. So you've said if I've met the requirements for an exception, statute that Parliament has said that outweighs my offending subject, depending on what the offending is. If I haven't, if I don't meet that exception, then we all agree that everything has to be looked at cumulatively.
No,
But at that,
hold on. If you don't meet the exceptions 1 and 2, the public interest requires deportation unless 1 or 2. So the starting point is, if you're not here for that long, or if you don't have that relationship, you're out. But the exception is in 1176. You can still be in, providing there are very compelling circumstances.
Yes,
They've got to be more than, if you're relying on the factors in 1 and 2, they've got to be more than that. If you're relying on factors not within 1 and 2, that's fine.
they've got to be more than that, or the public interest has to be reduced for some other reason.
Sorry, I didn't hear that.
They've got to be more than that, or the public interest has to be reduced for some other reason. That could make your case very compelling as well, as that following on from Akinyemi. So the balance has to be very compellingly in your favour. That's what those are very compelling factors. But my lord, I feel as if maybe. So my short submission is that in response is that, and this is in response to your question about paragraph 52, that the weight. That the statutory framework does not tell me the weight. It gives me an on-off threshold. If I don't meet that threshold, it tells me nothing about the weight that should be attached to either a factor which falls short of one of those thresholds or a factor which is not covered at all. But I'm not sure. It's clear that if we get to a very compelling circumstances test, then the tribunal is going to have to do its best with that, and it will have to direct itself. The weight to be attached to the public interest, it will have to take into account all relevant considerations, and it will have to ensure that it comes to a conclusion which establishes that there are very compelling reasons. And that's what the statute tells it. It doesn't tell that decision maker anything about the weight to be attached to those individual factors, apart from the public interest, the starting public interest, when it gets to that point. All it tells the decision maker is you couldn't have succeeded on your not quite subsisting relationship or your not quite British partner alone.
And presumably subject to irrationality, the decision as to what weight to attach to any particular circumstance lies on the tribunal.
So on the First-tier Tribunal, usually on the Upper Tribunal, if the Upper Tribunal were the decision maker, my lord, yes.
And that will hold good subject to a finding of irrationality.
Well, irrationality or failure to have regard to relevant, subject to conventional error of law, yes. My submission. That's the state of the law at the moment. You'll be familiar with the Schwidler case last year, which does seem to be suggesting that courts may have their own roles in determining proportionality, but only in certain limited numbers of cases. And none of us are arguing about that here.
Well, if it's important, don't assume I know about it, but just give us.
Oh, my lord, sorry. So it was. I'm not
just
sure.
Give us a reference.
It's Supreme Court last summer. Lord Sales and Lord Reid. Circumstances in which an appellate court should conduct a proportionality exercise for itself. Just short point. Should only do that normally in circumstances where there is a general point of law which may affect many other cases. So there will be. For present purposes, I think we're all agreed that the role of any appellate court would be to apply public law error and not to remake a proportionality exercise.
So, matter of fact, of this case, would a tribunal have acted unlawfully if it said the following? You do not have a genuine and subsisting relationship with the child. You have not seen the child for 6 years. That is a factor that you rely upon. there is nothing over and above the fact that you have no subsisting relationship with the child to cause me to reach a different conclusion on that fact. Is that lawful?
Well, it wouldn't be on the facts of this case because there are other factors that the tribunal was required to.
That's why I wanted to look at this, and there's no point trying to distract from the fact that there are 3 limbs. I'm doing my absolute best to focus on the relevant limb to try and get an answer to that. So if you had a serious offender, 5 years and 3 months, and the tribunal said you do not have a subsisting and genuine relationship with the child because you haven't seen the child for 6 years, and I see no factors dealing with the relationship with the child over and above the absence of a relationship, and therefore that is not a factor that amounts to a very compelling circumstance. Would that reasoning be sufficient?
Well, it would be sufficient as a starting point, but it wouldn't be sufficient to determine the appeal.
Right. What else must he do on dealing with the child issue only?
Well, the next thing that he or she would do would be to say, but I take into account. So, do you want me to give the specific?
Well, I'd like to know if it's lawful, whether it's lawful or not lawful for a tribunal to say the fact you're relying on is, I'm putting it neutrally, the connection with the child. I have found that that is not a genuine or subsisting relationship. I see nothing else to do with the relationship with the child, which causes me to think there's any circumstance, or certainly any compelling or very compelling circumstance. I want to know if that's lawful. And you say, be lawful as a starting point, but in relation to the connection with the child, you seem to be about to say that there is something else you must do.
Yes, of course there is. So what you must then do is determine whether there is nonetheless a relevance to the relationship or the potential relationship to the child. So what a tribunal would then be required to do, if it was receiving this submission, was to determine whether the potential relationship with the child, between a father and his child in this case, was capable of engaging Article 8. And certainly a prima facie it can be.
What does that mean? You mean it would be an interference within the Article 1?
Is there a family life which is entitled to protection, which is entitled to respect under Article 1? Yes.
And assuming they say yes, there is.
Assuming that there is, then the interference in that has to be justified.
Yeah.
And so
what must they do then?
Sorry?
What must the tribunal do?
So what the tribunal must then do will depend on... Are you talking about the facts of this case?
I'm talking about the facts of this case, but shorn of the other factors. Well, only the child.
So if the only thing in this case was the relationship with the child, the tribunal would have to then go on to consider whether this is a case of a type. I'm slightly struggling with this because I was going to take you to explain to you why I'm talking about a type of case. Is this a type of case which is covered by the exceptions? Because is actually the relationship between a father and a son from whom he has been separated a type of case which is covered by an exception? And if so, is there something which is over and above the exception? Because it can be. If I'm within the type, then I could be over and above. It would be difficult to establish that on the facts of this case, but at the level of theory, it's possible. Imagine that someone was in family proceedings, for example, long-standing family proceedings, in order to recover a relationship with the child. There was really clear evidence about the impact on the child and the...
So coming to this case...
You might well be able to... Sorry, may I just finish it? So one might well be able to find, even without anything more, that I was the kind of case that was covered by an exception, and there were very compelling circumstances relating to it. Alternatively...
So you're within the type of case, but there still has to be an assessment of the potential at some stage of a relationship being established. And you must give that some sort of weight and weigh it against the fact that he's got a 5-year, 3-month sentence for drug dealing. That's what should have happened here.
Yeah, so it would depend, wouldn't it? But if we really are operating at the level of theory.
I'm trying to get us to the facts of this appeal, actually.
Well, my lord, we're not, because you're asking me to disregard half of this appeal. So I can't do that. I can't answer your question on the basis of the facts of this appeal. You are asking me to deal with a theoretical appeal in which the only issue was the circumstance of the child. And I'm trying to suggest to you, if that were the only issue, then it's still possible, properly applying section 117C6 for an appeal of this nature to win. A tribunal would have to find that the particular impact on this child and father of keeping them apart, of stopping them from being able to develop a relationship through the family courts, was particularly intense, was likely to have a particularly harsh impact on the child or the father. It doesn't have to just be the child. And the tribunal would have to find, as this tribunal did, that removing the parent from the country was going to frustrate the possibilities or significantly reduce the possibilities of contact. And it's absolutely possible that a case of that nature, without anything more, could succeed by reference to paragraph 117C6. But in order to make that out, I've made the evidence about the child stronger than it is in this case. I recognise that's the hypothesis. But the difference in this case is that I also have two other factors which we relied on. There are two routes to it, as I say. One is to find that...
Does the fact that there are other factors, the mental health issue and the reception conditions in Dominica, to give them broad brush length, does the fact that there are two additional factors mean that even if you couldn't take into account the fact that you failed to meet genesis of the relationship and there's nothing else to do with the relationship, nonetheless, when you've got other factors unconnected to the relationship, you can still bring into account potential issues. That's the structure.
You add everything together. You add together things that might be part of an exception, things that might not be. You take into account any factor which reduces the public interest, and you conduct a balancing exercise. So you don't have to, so you can put together 5 not very compelling factors, 5 factors that fall outside or don't meet an exception, but if cumulatively they would be very compelling, then it doesn't matter that none of them fall within would meet an exception.
Right. Okay. Yeah.
So that's. I can't remember the authority. Someone may be able to help me. It may be in Yeltsin or it may be in Majera, where the court observed that over and above doesn't necessarily mean additional to. Is it in Majera? Someone can remember that. It means over and above.
Case, even if I were to be persuaded to think that this is not within 1176 as far as the child connection is concerned, you would still say the fact that there's a mental health factor and or a receptions conditions in Dominica factor, because they have to be looked at, you might still add a potential future relationship with the child as an additional thing to add. Yeah. Yes,
and you might also add, for instance, again, you might, if a tribunal so concluded, you might add any historical unfairness which would reduce the public interest in a particular case. So if there was a thought that the Secretary of State had behaved inconsistently or had denied someone a right to remain, which...
Well, if it was Windrush, for example, somebody been here for 40 years and he had a tax offence at the end of 40 years or something.
Or if you were a Gurkha child and the kinds of cases where this court's found historical injustice, Gurkha children, British overseas nationals, those kinds of cases. This
isn't an historic injustice case, so we don't need to worry about that.
No, but it could be an individual unfairness case as well. So,
but it's not suggested here.
It is. It suggests that he was denied an opportunity to...
Oh, that okay, yes, but he wasn't denied an opportunity, he didn't appeal against it. He appealed against one, got discretion leave and didn't do anything about it, and you say that's historic injustice.
Well, I say that the First-tier Tribunal thought so. It doesn't matter what I think.
Yeah.
My lords, can I wonder if I could... I'm slightly bogged down and I've got quite a lot of...
No, do please, yes.
Well, I've got the answers now because I wanted this case and you've given them to me now, so I should be quiet.
Well, my lord, so I'm just trying to see what I can cut. Can I? Yeah, so the next question, so I think you have my answers as to whether Hesham Ali is still relevant. I say yes. What does full proportionality test mean? I say it means, well, you have my answer on it. What did H.A. Iraq, what did the Supreme Court in H.A. Iraq do to the unduly harsh test? And just... I may be able to do this without taking my lords to it. In the KO case, Lord Carnworth both adopted the MK definition or the MK test for undue harshness, and also made an observation about the need for, or about undue harshness. I'd probably be better if I didn't paraphrase, but made an observation that something would not be unduly harsh if it consisted of the circumstances which would, the circumstances of a normal child. I'm paraphrasing badly. Let me just find the reference. It was a bad idea to try and shortcut. So we're in HA Iraq still. Yes, you see, if I go 462, and this was the Secretary of State's case, so this is the Secretary of State appealing against this court's decision. And the case was about, well, how should KO Nigeria be interpreted? And in KO Nigeria, the Lord Carnwath had approved the description of undue harshness which my learned friend Mr. Malik has referred you to, but also made an observation, paragraph 23, that suggested that a comparison should be made with the degree of harshness which would necessarily be involved for any child faced with a deportation of the parent. And what then happened was that in particular, this court treated that reference to necessary involvement as an additional test. And so you see that from Lord Justice Holroyd's decision in PG Jamaica, that the court must focus on whether the effects on deportation would go beyond the degree of harshness which would necessarily be involved for any child or partner. And Lord Hamlin, referred to that as the notional comparator test. You have to imagine the comparative child, and rejected it. You see that at 31 through to 40. That was a gloss on the MK test, which raised the threshold. It shouldn't be followed, and that's why at 45, well, at 41, Lord Hamlin reapproves the MK self-direction, and at 45, he observes this doesn't lower the test that had been set in KO, but it restores it to its original form without the additional gloss. So from that point of view, my Lord Justice Lewis was right. I'd respectfully submit to say that when, and this is not in my case, it's in Mr. Hawkins' case, that when the tribunal in his case directed itself to the KO test, it was directing itself to, if anything, a harsher test than the one that applied. So if there was any error in that, it was an error that favoured the Secretary of State. That's just a short point on that. So what the Supreme Court in HA restored the sort of pristine MK test without the gloss that raised the threshold. The next question I wanted to answer, and I think that's the last one on Article 8, is whether it's necessary, before going on to the very compelling circumstances test, to deal with or to address exceptions 1 and 2. And my submission is that's really what the HA Iraq Supreme Court is asking at paragraph 50. I don't need to take you back there, but again, my Lord Justice Lewis read that out, how exceptions 1 and 2 relate to the very compelling circumstances test. And so it's page 468, sorry, is the reference in HA Iraq. I'm going to go, and Lord, the Supreme Court answers that question by reference to NA Pakistan, and then that's in paragraph 50, and then by reference to Strasbourg in paragraph 51. NA Pakistan, and that, just if you could quickly turn that up, so it's at tab 16, page 228 of the bundle.
Where are we?
Sorry, it's tab 16. Actually, if my lord, if we could go to page 241 within. So this was the case which it overlapped with. So this is the first leading case on the statute, the 2002 Act in this court, and it was decided while Hesham Ali was pending in the Supreme Court. It was decided after the hearing in Hesham Ali, but before. So the Court of Appeal had overtaken the Strasbourg Court. And I'm in paragraph 20 of the judgment.
Page.
So it's page 242.
Thank you.
And Lord Justice Jackson, in paragraph 20, so it starts on page 241, but he approves observations he'd made, or he refers to observations he'd made in in a case called JZ Zambia. And at that point, the Secretary of State was saying, if you don't meet the requirements of an exception, if there's a near miss of the exception, then you have to disregard the factors relevant to that exception when you go on to consider very compelling circumstances. That would be the case if it was found that I don't meet exception 2 because of my relationship with my child. Then when I go on to consider very compelling circumstances, I have to ignore it. And top of page 242, so that's a quote from JZ Zambia. It would be bizarre if the Secretary of State were required to ignore such matters altogether when considering whether there are exceptional circumstances. So a near miss won't get you home by itself, but it still remains a relevant consideration when considering whether there are exceptional circumstances. And so that's my answer, Muller, to your question. When I'm considering whether there are exceptional circumstances, I have to consider the factors that have just missed out or have missed out on an exception. They go into the whole balance. And you'll see at paragraph 21, although that was initially a contentious issue, it was conceded by the Secretary of State in paragraph 21. So the approach taken by this court in JZ Zambia becomes approved and is no longer challenged at the stage of NA Pakistan.
Is 29 and 32 correct?
Sorry.
Are paragraphs 29 and 32 correct? Did they properly set out the law?
Sorry, can I? Well, so 29 is correct if that's the only thing you're relying on. Sorry, no, I'm sorry. So 29, yes, it is correct. So what that says is that a foreign criminal is not altogether disentitled from seeking to rely on matters falling within the scope of the circumstances. A foreign criminal is entitled to rely on such matters, but he would need to point to features of his case of a kind mentioned in exceptions 1 and 2. And that's I say that potential relationship with a child is a feature of a kind, or features falling completely outside the circumstances described in those exceptions, which made the claim based on Article 8 especially strong. And the way I read that is that you put everything together. You put something which falls within the exception, together with something that falls completely outside the exception, and together with something that is of a kind mentioned in the exception. That's why I said that there are two ways of looking at this case: either potential relationship with a child, but dependent on family court decision, is of a kind of a relationship, a genuine and subsisting relationship with a child, certainly from the child's point of view, or it falls completely outside, in which case it just has to be weighed in separately. And 30 onwards is giving examples. It's trying to think, well, if all you've got is the impact on your child, then that's when you're going to have an unduly harsh. That's Lord Justice Underhill. You've got to have an extra unduly harsh impact. But alternatively, if you don't have a bare case like that, then you weigh everything together. But the essential principle in 29 to 33 of NA is that you put everything together. there are specific examples there, but they're not exhaustive, and they're not. As far as they're examples, they're probably not ratio. They just illustrate the fact that you have to weigh everything together, whether it's within an exception, whether it's outside an exception, whether it's of a kind that would be covered by an exception. So, unlawful residence, for instance, or partially unlawful residence. It's yeah, so Moylan and friend takes me to the end of paragraph 32 at the top of page 245. Similar, that draws the strands together. Must look at all the matters relied upon collectively in order to determine whether they're sufficiently compelling. So the test is sufficiently compelling to outweigh. There's no restriction on, you don't exclude something just because it's fallen within a different exception or because it doesn't fall within an exception.
Yes.
My lords, I've already given examples. Sorry, I'm trying to skip through because I've got too much. I've already given examples of factors which we say can reduce the public interest and therefore reduce the amount of personal circumstance that's needed to outweigh it. Examples are conduct since the offence was committed. We've seen that in Heshamali and in Akinyemi. Rehabilitation, that's in the Akinyemi again. Delay. There are cases on the relevance of delay to deportation cases. The case MNT Colombia, another Jackson case from 2016.
And any of these relied on here, conduct since the first set of offences, rehabilitation or delay, or any of these relied on here, on the fact of this case? Just so that I know, because I've got...
No.
They're not relevant here.
No, I'm not. I'm so sorry, but I am answering it. I'm answering submissions that were aimed at two different cases.
Yeah.
No, I bet you're absolutely right. They're not relied on here.
Does it make it worse that after he was served a notice of deportation, he committed more serious offences?
Well, my lord, of course it makes it worse that he's committed a large number of offences, or a number of offences. Of course we accept that. There's someone who gets multiple sentences. That's plain. They've got a higher threshold to meet to balance it. My answer to that on the facts of this case is that was
And that's why there was a follow-up letter.
Yeah.
So
Yes,
bringing it into the picture.
Yes,
So
exactly.
there's nothing on the positive side from Mr. Lewis's balancing point to do with conduct rehabilitation of delay, the possible way in which the 2015 application for leave was dealt with. There's nothing here that you're relying on the fact that I appreciate you dealing with the generality,
yes.
but we actually have to deal with an appeal, and there'll have to be a judgment saying whether Mr. Lewis wins or loses. But you're not relying on conduct rehabilitation as adding positive weight on the plus side.
Certainly not in the context of no. That's not. Let me just. My learn from Mr. Ahmed was in that. I'm not really. There was a positive finding by the. I'm not going to be taking you through the decision because there's not going to be time, and I'm going to ask you to read the determination, of course. But you'll have seen that there's a positive finding that the appellant had a genuine desire to.
That's clear. Yes.
really do it.
You just referred to conduct rehabilitation.
But I'm not.
Today.
We
I
have
didn't
not.
understand conduct to include positive potential relations with the trial. So I just want to be clear, and I've written down you're not suggesting that conduct rehabilitation delay add weight to Mr. Lewis's case for non-deportation.
So we're not saying the only factor that we're saying might affect the public interest is the fact that there was a historical failure to deal with this case properly.
Yes, the question as to why you didn't get indefinite leave
Yeah.
rather than discretionary limited leave in 2015. Yes.
But the way in which that's been relied on, and I think my learned friend would make this point if I didn't, was that it was relevant to the weight that should be attached to private life. Rather than being relevant to the weight to be attached to the public interest in deporting him. So I would say that it has not been submitted on his behalf, but there were factors which reduced the weight to be attached to the public interest in deporting him. That's not the way the case was presented.
That makes it sound like, just so I'm absolutely clear, that makes it sound like you're saying that the 177B factors, little weight to be given to limited or precarious shouldn't be taken into account here, because in reality he should have been seen as somebody who's had indefinite leave to remain. That seems to be what you're saying.
Well, so my lord,
just so I'm clear.
Yeah, I was planning on dealing with this in response to my secretary to my own friend's grounds when I get to it. Our submission on the on private life was that the Supreme Court, and I can probably avoid making this later, so the Supreme Court in Rupia made clear that Section 117B is not and does not impose straitjackets, particularly 117B 4 and 5. That's the term that's used, and I think my own friend took you to it this morning, and that in this particular case, the judge was entitled, the First-tier Tribunal was entitled to attach significantly more weight than you would normally have done to a private life established while a person was either precariously or unlawfully in the UK because of the loss of a chance, and the loss of a chance that appears to have been the responsibility of the Secretary of State, or may.
Did you say loss of a chance?
The loss of a chance, so loss of the opportunity to either to be granted ILR or to have an appeal.
Well, why didn't he apply again? I mean, I know he hadn't got it when he was 16, and he got it when he was 18, but then he could have applied again.
My lord, I'm sorry.
Subsequently, he's had more than, well, he wouldn't get it now because of the criminal offences, but he had time to apply again.
My lord, he did have time, but I can only say what the First-tier Tribunal. I'm not making submissions of fact. I'm trying to identify. I'm trying to respond to the Secretary of State's submission, which is Secretary of State's submission is the First-tier Tribunal acted unlawfully by attaching. I'm paraphrasing, and probably not quite accurately because I've not reached that bit of my text. But the Secretary of State is saying the First-tier Tribunal acted unlawfully by attaching weight to private life, which was established when the appellant was in the UK either precariously or unlawfully. And I'm simply saying our submission is it would not be right to say. So our submission is the First-tier Tribunal gave a reason for that. And it was a reason which the First-tier Tribunal was entitled to give, and it was consistent with the Rupia guidance. I'm not making a primary submission myself.
The Secretary is saying acted unlawfully by failing to give little weight to the private life, and you're saying, under 117B, and you're saying the FTT gave an acceptable reason for saying, no, we're going to treat it as not having little weight, and put it into...
I'm saying three things. It gave a reason. It didn't give no reason. Secondly, that reason was capable of attracting weight, and thirdly, that the weight that the First-tier Tribunal attached to it was a matter for the First-tier Tribunal. I'm saying those three things.
Yeah, I'm really sorry about this, but it is quite important to get it clear in my mind. It is my fault, and I do apologise. 177B here says little weight would be attached because it's precarious, or whatever the phrase is. And you're saying, no, the Secretary of State is wrong to say they had to downgrade the Mr. Lewis's claim because of the precariousness. Does it go any further than saying the tribunal weren't wrong about Section 177B?
My lord, sorry, I'm a bit confused, so I'm not sure that I've understood the question that you're asking me. So I'm just going to go straight to my submissions on that ground, if I may. But I'd really like to I have only a small amount of law left.
No, don't go through.
Don't worry.
Go through the order, and you'll come to it when you come to it.
Thank you very much. Yes. So because I'm trying to answer the question.
Don't worry.
Yes. So I'm trying to answer the question. But now, is it necessary? It was a question that I think my Lord Justice Moylan asked yesterday. Is it necessary to deal with exceptions 1 and 2 expressly first before going on to deal with very compelling circumstances? Is that a mandatory process that the tribunal has to go through? And therefore, is it, as I think my learned friend suggested, an error of law not to have done that? And our short answer to that is no, it is not a mandatory requirement. It may be good practice, and it may often be good practice to deal with exceptions 1 and 2, or 1 or 2, before going on to very compelling circumstances, but it is not mandatory, and it's not an error of law not to do so. 3 cases on that. Firstly, Yeltsin, that's tab 31, page 534. It's the case that my own friend Mr. Malik left to us to go through with you. It's a case in which, so just background, Mr. Yeltsin is a serious offender, 5 years, 4 months for knife offence. The First-tier Tribunal allowed his appeal by reference to very compelling circumstances, but expressly declined to decide whether any exceptions had been met. And you see that from page 543. And it's so you see how the issue arises. It's page 543, paragraph 29, subparagraph 4. It probably, to make this, to understand this, if my lords look at the bottom paragraph, so it's an extract from the judgment, page 542, paragraph 36, the First-tier Tribunal says, the exceptions to deportation do not apply to the appellant. He has been convicted of serious offences and sentenced to a term of 5 years in prison. So, and that's it. They do not apply, and there's no finding. And you then see Lord Justice Underhill's observations about that self-direction at 543, 29, subparagraph 4, at sideline E. Para 36 correctly states that the exceptions do not apply because the appellant is a serious offender and no further reference is made to them. So the First-tier Tribunal in that case had declined to decide whether the exceptions were made out, had declined to consider the factors in the assessment. That might seem unexceptionable, but as will appear, there is an issue about whether the FTT was in fact obliged to consider them expressly because of the over and above requirement in subsection 6. So that's exactly the question that the court asked yesterday. And shortly, Lord Justice Underhill's answer is no, wasn't required to. You see that his consideration of the point is on, it starts on page 551, paragraph 53. And again, we go through the same list of, so the same primary authorities, HA Iraq, NA Pakistan, and then we get to the issue. So on page 552, paragraph 54, it might be thought from the fact that the exceptions are a self-contained shortcut, that they have no role to play where a full proportionality assessment is required, and accordingly, in the present case, the FTT was right to make no reference to them, but the complicating factor is the requirement that the public interest required deportation unless there are very compelling circumstances over and above. And so that is the complicating thing. Now that's the question that is posed. And what the Upper Tribunal had done, you see at the bottom of page 553, paragraph 59, the Upper Tribunal held that it followed from the judgment in NA Pakistan that the FTT was obliged to consider expressly, firstly, whether the exception was met, and secondly, expressly to identify what was the something more. And then you see the decision on that over the page, paragraph 60, I do not believe it is correct. I do not believe it is, sorry, it's top of page 554, paragraph 60, I do not believe it is necessary as a matter of law for a tribunal in a serious offender case to make explicit findings in the claimant's favour on the questions enumerated by UTS 1 and 2. And then we have the terminology which is used here, which is a little bit complicated, but an exception overlap case is a case which includes factors which would form part of an exception. And the reasons given by Lord Justice Underhill for his conclusion are, firstly, that in some cases that so why is it not mandatory to go through this process? Paragraph 61, in some cases it will add nothing anyway. And 62, it may be...
Because the particular facts have been spelled out and everything that's in the exception would have been in that section dealing with facts. Yeah.
Well, sorry, I'm skipping through. I'm simply asking the question, is it mandatory? There may... So he gives example. So that's an example of a case where it wouldn't be necessary. It would gain nothing. And then two. So the second reason is paragraph 62, because actually it may be too difficult to spell out, and that's like a reference to the kind of holistic assessment which my lord referred to in the context of the family courts. It may be difficult to separate out different strands of weight in circumstances where the factors are incommensurable, and that's so. A factor which reduces the public interest is incommensurable with a factor which increases or is incommensurable with evidence of the strength of relationship between a husband and wife. It's very difficult to calibrate their relative weights. It would be an unrealistic burden to have to decide and specify in every case whether the something more consists of exception and so on. And then 63, not inconsistent with NA Pakistan.
Yes.
Bottom of 64 looks at the spirit of the HA Iraq guidance. And you can see from paragraph 67, it's clear enough from 60, this is ratio in this case. That's the ground which was before, the matter which had to be considered in Yeltsin was that a freestanding error of law? Lord Justice Underhill finds no, and paragraph 68, for those reasons, I don't believe that the FTT erred in law. The two cases which my learned friend relied on as contradicting that are Capicania and Majera, which I'm going to ask you to go to very quickly again. They're tabs 38 and 39, and maybe that I can deal with them without taking to them. You've been taken to them various times. It's page 712, paragraph 27. In Capicania, the 6 lines down from the top, put shortly, the phrase over and above does not always mean the same as addition to.
Sorry, I haven't got there yet.
Sorry, Lord. It's page 712.
Thank you.
The paragraph which overlaps from the previous page, 6 lines down, put shortly, the phrase over and above does not always mean the same as in addition to.
Sorry, I haven't got it. Which paragraph?
Well, sorry, it's page 712, paragraph 27, and it's.
Oh, so, okay, I'm with you now.
Yes, sorry. So it's so you're looking at the overall weight. So you have to read over and above purposively. It doesn't mean in addition to necessarily, it means weighing more than. It means weighing more than, not in addition to. And that's just to jump through whether there. Yeah, sorry, if I just go, I'll jump through some of this. So if I could ask your lordships to look at the discussion, which is on pages 718 to 719.
Yes.
Paragraph 42. Sorry, 41 is about full proportionality assessment. My submission is that the characterisation there is consistent with Heshmali and with everything, with the various different ways in which we've tried to explain that test. You conduct the balancing exercise in order to establish whether the statutory test has been met. 42. There is no. Sorry. Yes. 3 lines down, the FTT does not have a general license to bypass exception 1 and exception 2 and go straight to it. It doesn't have a general license, but nor is it. That is not a conclusion that it's bound to. Has to think about the FTT has to think about whether that's the right thing to do on the facts of a particular case. And so, 43, in order to satisfy 117C6, something more is required. And then Lord Justice Underhill's 2 possible cases. None of that is controversial. You need to show something more It doesn't have to be something in addition to, and there's no general license to ignore exceptions 1 or 2. But nothing in this judgment contradicts what Lord Justice Underhill says in Yeltsin, which is that there is no mandatory rule that you go through exception 1 and 2 before you come on to, you deal with exception 1 and 2 expressly before you come on to very compelling circumstances. And also, these observations are not ratio in this case, we say. Paragraph 44, you see that what's lacking here, the reason why this appeal fails is because there is a failure to give adequate reasons to explain why there is something above and beyond undue harshness. So, in fact, the ultimate error which Lord Justice Bean finds in this case is perversity. If you looked at this case, even if you had been entitled to find undue harshness, you simply couldn't have found on the facts of this case that there was undue harshness.
Yes.
The other case is Majira. My learned friend relied on paragraph 11 of Majira, so it's page 726, paragraph 11.
Could you give me the reference, please?
My lord, sorry, yes, it's Majira, it's tab 39, page 726, paragraph 11.
Thank you.
The significance of over and above is that you must not only establish circumstances relating to private or family life, but you must also be compelling to a degree that goes well beyond anything that does or would. Well, that's read literally. That's contradictory to everything that we've looked at, because it's suggesting that you can only ever succeed with very compelling circumstances if you also meet one of the exceptions. That can't be what Lord Justice. Sorry, I've forgotten whose judgment it is. Lord Justice Warby meant there, because it would mean, for example, that you could never ever succeed on very compelling circumstances if you're a medium offender.
Say that again, you could never succeed. And
if you're a medium offender, you're only going to have to rely on very compelling circumstances if you have not established circumstances. So that can't be right. It's not ratio, and it can't be right. There's nothing in this decision which suggests that it's necessary to make a finding about exceptions 1 and 2 other than that. And again,
it wasn't 7 years, so in context, it's right then.
Well, my lord, no, but it's not, because that would impose a requirement which is inconsistent with NA, which is an NA is approved in HARR. An NA.
I'm just not following this. Every judgment must be read in context. This is a 7-year prison sentence, so we're looking at a serious offender, which is saying that, dealing with the fact that this case is a serious offender case, the circumstances must be compelling to a degree that goes well beyond anything that does or would fall within either of the exceptions. Why is that wrong for a serious offender?
Because it's not that part, it's the first part. The serious offender must establish circumstances that provide a basic basis. Maybe I'm misreading it, in fact. Maybe that's not. Sorry, I read the first two lines as implying that you have to, in fact, find that an exception is met, and reading it, that's not what it says, is it? So
No, it's not.
No, I'm sorry. Yes, yeah. I've just misread it. So I'm attacking a straw man. I'm so sorry. That's not. So that what's that saying is in fact uncontroversial. You're absolutely right. It's just saying that you meet the threshold. But my lords, anything which is said about the exception 1 or 2 test in that case is obiter in any event, because in fact the error of law which was found in that case was an absence of reason. And the conclusion I'd invite you to draw from that, firstly, is that you're bound by Yeltsin. There's no subsequent authority that disagrees with it, that would require you to choose between 2 conflicting authorities. The Yeltsin is consistent with the aims of the statute. it may well be that in a case like Capicania, a clear approach of going through exception 1 and then going through comparing circumstances would make it less likely that a judge would fail to give adequate reasons or would reach a perverse conclusion. So it's a best practice, potentially, at least in some cases, but not a mandatory requirement. Right, those are my submissions about Article 8. I've got about the other submissions I have about law, and then I will be very, very quick on the facts on the appeal in this case, because we've touched on so much of it in the course of it. Firstly, you've had submissions about the tribunal, so a court's self-restraint in hearing appeals from the lower tribunals. I don't intend to take you to any of those again, except just to refer you to, and I don't need you to turn it up, it's low, tab 24, page 407, paragraph 29, and it's citing Lord Justice Lewison in Page or Fargate, I'm sorry, I don't know how to pronounce it, UK Limited, simply concluding, it's simply making clear that the principles of self-restraint apply, and I quote, not only to findings of primary fact, but also to the evaluation of those facts and to inferences to be drawn from them. I think it's in response to something that was raised yesterday. It's the same level of restraint to be applied to evaluations and inferences as to the fact-finding itself. But otherwise, my lords, you already be taken to all those authorities and they're all set out in the skeleton arguments. The next point is the latter principle. Again, that's been dealt with in detail. I have 3 things to add to it very briefly. Firstly, there's no basis for suggesting that the latter principle is confined to refugee claims or in some way overridden by the statute in Article 8 claims. Exactly the same principle applies. The parties to adversarial proceedings in the tribunal who are bound to work together to assist the tribunal in compliance with the overriding objective have the same duty to identify the issues which are raised. In refugee law, there are standard issues which everyone knows that it may be necessary to show that you fear persecution, that it's for a convention reason, that you won't receive sufficient protection if you fear a non-state agent, that you can't internally relocate. Those are just as clearly set out. They're requirements of refugee law, and they're in statute now, many of them, under the 2022 Act. Latter is a refugee convention case. There's no suggestion that the fact that a tribunal knows the issues which would normally arise. The whole point of latter is that the parties narrow those issues in the same way as, my lords, I think I'm probably preaching to the converted on this. I think that we simply say the point of latter is that
of general application
is that you know a list of issues which are potentially relevant, and the parties work together to narrow those down, so the tribunal doesn't waste time on issues which are either not material or not disputed. Second thing is that the latter principle respects and so approved in this court, respects the tribunal's own rules, the tribunal's own practice statements, which it has, which are designed to govern procedure. It's this court respecting the tribunal's governing of its own procedure. My Lord Justice Stuart-Smith will recall the judgment in AAB, which was also about the weight should be attached. You considered in that, maybe you don't. I recall. It's a case about when cases should be remitted to the First-tier Tribunal, and there was thought given in that to the reasons why the tribunal, obviously the reason why the tribunal produces practice directions and the respect that should be given to them. And it's the same principle here, that the tribunal is entitled to seek to manage its proceedings by a rule like the rule which is reflected in latter. And, my lords, the third point is that the latter principle is derived from the broader principle. I don't need you to take you to it. You see it in Lord Justice Males's concurring judgment. It's ACTA, tab 32, page 576, paragraph 82. Forms part of the ratio. You see that from paragraph 76, and Lord Justice Mayo says it's not a legitimate ground of appeal to this court that the UT has failed to take matters into account when it was never asked to do so, and when it's fully addressed the submissions which were made to it. ACTA was a case where the Upper Tribunal had acted as the first decision maker.
Could you possibly give us a page number for?
I'm so sorry. So it's page 576.
Thank you.
Paragraph 82, and the previous page, paragraph 78 for the I agree. Just because it's a short supplement.
Yes.
Procedural discipline. My learned friends have relied on the OSB approach. There's also a recent decision which is in the supplementary bundle from Lord Justice Lewis in Spence. Both cases where permission was granted to run points that hadn't been run in the Upper Tribunal below, and the Spence decision refers to the Singh and Das principles that you shouldn't grant permission if granting permission, or if on a point which would require different evidence to be put in, or which would have caused proceedings to have been conducted differently below, or which would cause prejudice. And it's plain that the tribunal, that the court has the discretionary power to grant permission in those circumstances. I would simply draw your lordship's attention to the tribunal case of Rye and Dam. It's in Supplementary Authorities 4. It's quite a short decision, and I don't want to spend time taking you through it, but that's the Upper Tribunal expressing its concern about grounds of appeal which are not clearly expressed, or which before it. So the section on that is from paragraph, so it's on page 55, paragraph 5 onwards. Again, it's so what the Upper Tribunal has to say about its about the requirement that grounds be properly pleaded before it. It starts out in Rule 2.4, so it starts out in the party's duty to assist the tribunal in the overriding objection, the same as the origin of the latter principle. And I just invite you, I was going to take you to some points, but I think it's not terribly, if I could just ask you to read through to the end of that section.
Right.
It's just a counterweight. It's a reminder. My lord said in the Spence case that the court should be cautious in granting permission on those grounds, and it's a further reason why the court should be cautious. And it's nothing else. We don't. My learned friend didn't make a big thing about it. I was ready with submissions about it if there was going to be a major point made about the use of that the use of that discretionary power. But it's not something that.
It doesn't seem to arise on the facts of this case. It did in the other case.
My lord, yes. But I'm not. I'm addressing the points of law on both cases. That's the only other legal authority I was going to address you on is the Ahmed case, but I don't think I need to. We've dealt with what needs to be. So that's the case. That's the concurrent family proceedings case. We recognise that there aren't concurrent family proceedings.
Well, that's dealt with after later, whether you should adjourn family proceedings pending the outcome. And there are lots of things in there saying, yeah, there's no order. Even if you've got an order, that might begin to start being family life, but he hasn't even got that far.
So,
and in fact, from recollection, we dismissed the appeal and said it was accepted to proceed with the FTC.
Well, it was.
I'd have to go back and look at it.
Model, yes, and it was another case in which my other friend appeared before you. But the point about that was that in that case, a person was arguing that he should be granted leave to remain while his family proceedings were pending.
Yeah.
The important thing was that the whole of that was explored in the First-tier Tribunal, and quite strong adverse credibility findings were made about the. I'm sorry that I'm speaking about my learned friend's client, but that's that. I could take you through the paragraphs, and again, I don't really need to spend much time.
That wasn't for the deportation case, I don't think, from recollection.
My lord, it wasn't a deportation case.
Was it? But in any event, it did.
The point the 2 points. Firstly, that the finder of fact about credibility. So that case turned very significantly on a finding that the appellant in that case had no. I paraphrase, but I think accurately, had no genuine interest in contact. Certainly had not prioritised.
Yeah, and this one clearly does. The tribunal found.
Yes, exactly. So your starting point. So I'd simply say I recognise that there may well be. Again, he's not Mr. Ahmed is not my client, and I recognise that there may well be evidence that might be used in other circumstances to counter that. But certainly, the basis on which that case came to this court was that there had been findings of fact by the First-tier Tribunal that appellant was not interested.
With manipulating the system, that's not the case here. The finding of fact is that he's got a genuine interest in having contact with his son.
My lords, exactly. And that's really all I wanted to draw your attention to on that. So now, the Secretary of State's own grounds. My lords, you have the background to the case in our skeleton argument, as you have it in Moylan and Prenscout. I
Yes.
don't intend to take you to that at all. The decision itself is in paragraph, in the core bundle, pages 118 onwards. You see it's divided up in the normal way, immigration history, and then it goes through the family life and then the private life rules. The point that is taken about the family life is that there was no evidence that there was a genuine or subsisting relationship. You see that on pages 122 to 123. And in the alternative, it was accepted that Mr. Lewis's son, it would be unduly harsh to require him to leave the UK, but it wasn't accepted that it would be unduly harsh to require him to stay because there was no evidence that Mr. Lewis was paying any part of his life. And also, this is on pages, that's at the top of page 124 of the core bundle. There's then a section on private life, and the Secretary of State's position was there is no, you've not been lawfully resident for most of your life. You're not socially and culturally integrated. My lords, I just wanted to draw attention. It's really the only reason I'm taking to this, because you can read it. But on page 125,
Yes.
you see a clear reference in the Secretary of State's decision to lack of financial independence. It's in the final paragraph of the section on social and cultural integration. I just wanted to apologise. We missed that when we wrote our second argument. I wrote to the court and we'd simply say that that's in the context of social and cultural integration, but nevertheless, that was plainly before the tribunal. 125 to 126, significant obstacles, and then a very short section on very compelling circumstances at the top of page 127. There's then a section on Article 3, which always seems to be in a case like this, and unsurprisingly, given the evidence that was before the Secretary of State, that's rejected. So that's the appeal which is under, that's the decision under appeal. As you've seen, there's a supplementary decision which deals with the further offending.
Yes.
And I've accepted that makes the threshold higher. The First-tier Tribunal decision is at 86 to 109 of the bundle. My lords, the single issue is set out at page 91, paragraph 19. This is a case where we'd submit immaculate self-directions as to the law. I'm not going to take you through, but they start around paragraph 56, and there are a series of references to the correct legal tests and the correct approach. They run through from 56 through to 66. There are positive credibility findings which are not challenged before this court. You see those, for instance, on page 101, paragraph 73. Paragraph 77, the bond between the appellant and his child, and my lord referred Moylan and friend to that earlier on. There are positive findings about the credibility of the appellant's stepmother, the now respondents, the appellant their stepmother, the findings about weight that can be attached to evidence which was presented by witnesses who didn't attend, acceptance that weight could be attached to expert reports, and reference to contents of those reports. None of those findings of fact are contested before your lordships. And the way we would put the case about the appellant, the respondent's relationship with his son is that it was a bond which was initially very strong and it was severed when the appellant split up with his former partner, and then he has a genuine desire for it to be restarted. He's made an attempt to restart it while he was in prison, or made an attempt to go to the family courts.
Where
and
is
that was
that in the
impossible.
decision?
So he says, I'm so sorry. Well, I'm just trying to remember whether it's in the decision or whether it's in the witness statement, which is...
He says something about it in his witness statement, but there was no finding that he had started to attend, and he gives the explanation to why he wanted to make family contact applications, but he couldn't, he says, because of him being in prison. But I didn't see any finding by the FTT, and it found lots of positive things in his favour, and yet it didn't find, as a fact here, that he had attempted to but been prevented from making applications in the family court.
Well, that may be that
I might have missed it.
no, and I might have missed it as well. I'd simply say that there is a global positive credibility finding which takes into
We've got
account.
that, I know,
Yes.
but it's a very specific point about the decision, yeah. Well, I'll read it again, don't worry, but I've read it lots of times, I just couldn't see it there. But I may have missed it.
No, that's well. There's the evidence that it's at page 77. It's his stepmother's evidence that the current impediment is his incarceration.
Yeah.
It may be that goes less far than what I said.
Yeah.
It may be that in which case I'm sorry. So if I'm wrong, and I think it would be a poor use of time for me to try and find
I'll read it
it.
again.
If it's not,
You
if
said
it's
it
not
so
there,
competently, I thought you would have...
well, I'm sorry.
Don't worry.
The confidence probably comes from me trying to go quickly. But that's the explanation. The explanation which was given in evidence, which was found to be credible. I would invite you to look at the witness statement itself. It
Did
includes
you give
quite a lot
oral
of-
evidence?
Yes,
And you cross-examined then, presumably?
he was cross-examined and gave oral evidence. You see that from so you can see
That's okay, no, if you say this...
both he and his stepmother were cross-examined, and it was following cross-examination they were found to be credible, and of course that the positive conclusions about his intentions were reached. Secretary of State appeals to the Upper Tribunal. You have a summary of the grounds of appeal in our skeleton argument, and I'm not going to take you through those, but simply to say that the grounds of appeal to the... So I think probably I said that the OSN, the issues about OSN don't apply in this appeal. They do, because we say that the grounds of appeal to the Upper Tribunal didn't include, with one exception, didn't include the issues which are being relied on now, we say. The exception is that it's the point about section 117B. So our summary of the grounds of appeal is in our skeleton argument at paragraph. It's at paragraph 13, pages 3 to 4 of our skeleton argument. So the error of law was said to be failing to give adequate reasons for findings on a material matter, and we've identified 7 things that were said to be wrong, and we say that only the last of those, the section 117B point, is continued in this court. The other points taken in this court are new, we say. But permission's been granted on them. And so in response to then the Upper Tribunal reached its decision, I've indicated that there are parts of that decision which are quite hard to, would be quite hard to uphold, and we're focusing really on the Secretary of State's ground one.
Is that right? If the Upper Tribunal has gone wrong and didn't do its job, at the very least, don't we have to set aside that decision and send it back? I haven't thought about this yet, but because I haven't quite appreciated the four factors that you say they went wrong on. But if you've got a right to appeal and they go wrong, doesn't it mean that they at least have got to go back and do it again?
My Lords, no, because you'll decide for yourself. But in order to determine ground one, you'll decide whether the FTT did in fact make any errors of law. And if you decide that the FTT didn't make any errors of law, then any mistakes or any lapses in reasoning in the Upper Tribunal will be immaterial. So I think it's also in Yeltsin that Lord Justice.
Common ground.
Yes, it's common ground. Thank you. It's that. It's a matter. I think it's in. Is it in Yeltsin?
Yes.
Don't worry, I've got any error by the Upper Tribunal would be irrelevant because the decision that
it's a matter which only admits
no error in the
one
FTT.
answer.
I've got it.
So then, responding to the Secretary of State's grounds of appeal, I don't have very much to add to what we say in our skeleton argument. I'll just go through very quickly. So the skeleton argument deals with the individual grounds of appeal, starting at paragraph 24. I'm just really aware of the time. I think this is something where I can probably rely mainly on the skeleton argument.
Very well.
Just very quickly to summarise, the prospect of the appellant or the respondent now establishing a relationship with his son in the UK, we say that is a latter point. It wasn't suggested before the First-tier Tribunal that there was no prospect, or it was unlikely or impossible that Mr. Lewis would establish a relationship with his son if he was allowed to remain in the UK and make an application to the family court. Nor was this a submission that was made in the Upper Tribunal. And we say there's no proper basis in law for that submission. Everyone can see the factors that might weigh against contact being granted, but everyone can see the factors that might weigh in favour. The original strong relationship, the fact that there's no dispute about the family life, the general presumption in favour of contact between both parents. You can see the reasons which might be against the long period of not seeing him, and the fact that he's been in prison for parts of that period. But it's certainly not possible to say that it's unlikely that we say that contact would be granted. In any event, that would fall foul of the principle which my Lord.
What's the up-to-date position?
The up-to-date position at the moment, as I understand it, is that the appellant is attempting he's attempting to get lawyers to help him.
Has he made an application to the family court?
No.
Well, that doesn't do much good for the prospects of them getting together again.
No, it doesn't do a great deal of good. But it may depend on what the reasons are, and I've had instructions on what the reasons are for that. But
just remind me what date he was released on bail.
He was released in August. He's been out.
August 2020.
But as my Lord said, if you did make clear that that's not relevant, I have instructions about why it is that application hasn't been made. I'm not proposing to put that evidence.
No, but it is a fact.
Yes, it's a fact in response, but it's an incomplete fact without evidence.
Yeah.
It's something I'm telling you in response to a question on instruction. But yes, my Lord, but it certainly doesn't. It's certainly not a good thing in terms of the prospects of reunion. But nor is it fatal. Yeah.
Nor is it what?
Nor is it fatal. Just
Fatal.
yeah.
No.
Not given the background. I don't think I should be making submissions about facts, especially in circumstances where I have instructions about things that I'm not.
Yes, thank you.
Our main point is that this is a latter point. It wasn't.
Yes.
This isn't the way in which the case was pleaded. The second ground is the failure to determine the best interest of the child. Again, we said it's the latter point. It was not suggested that it would not be in the best interest, not part of the Secretary of State's case before the First-tier Tribunal, that it would not be in the best interests of the child. The Secretary of State's submissions were about whether there was a relationship at all, and then about whether the application could be made, whether or not Mr. Lewis was deported. There wasn't a submission made that it would not be in the best interest of the child that he should have contact with his father.
I don't see how a first-tier tribunal would be able to deal with such a suggestion anyway.
Well, it might be able to deal with it if there was clear evidence as to why it wouldn't be.
Well, I suppose if there's some order prohibiting the father, or if he...
Well, exactly.
It's not this case, but
No.
case of abuse or something.
Yes, there might be. You can imagine, but the submission wasn't made, and there was no evidential basis for the submission, which is presumably why it wasn't. So the third point that's made by Moylan and friend is that it was perverse to treat this as a factor which was. But the way it's put in the grounds is that it was a very compelling circumstance. We say it wasn't necessary for the appellant to establish that this, or for Mr. Lewis to establish without more, that the issues relating to his child were very compelling circumstances. But also, just back on best interest, I do accept that there is no assessment. I, of course, accept that there is no express assessment of the best interest of the child in the First-tier Tribunal's decision, and it certainly appears to be the case that the focus of the First-tier Tribunal in dealing with the relationship was the impact on the dad. And of course, it's perfectly possible on the facts as found. It's having a profound negative impact on the dad that he's not having contact with his son. For the purposes of reaching that conclusion, it wasn't necessary to assess the best interest of the child. But I do accept that there isn't any separate consideration of the best interest of the child. You have my submission as to why that doesn't harm the judgment. It certainly doesn't amount to an error of law. On perversity, I've set out to you the reasons why. I think I've set out to you in response to questions earlier the reasons why we say it was not perverse. Stepping back from it, we don't have to answer the question. The question doesn't arise, would it have been perverse to treat the relationship with the son without more as a very compelling circumstance, because that's not what the Upper Tribunal did. The First-tier Tribunal did. But in answer to the question what the First-tier Tribunal did, it treated it as one of the three factors which combined to create very compelling circumstances. We say it's not shown that was perverse. And then the fourth and fifth sub-grounds of ground one we took together in the skeleton argument, which are the two section 117B points.
Jesus.
On the private life point, you already have my submission on that. So the weight to be attached to private life or to residence, private life to a length of residence while someone is not lawfully in the UK or in part not lawfully in the UK, and then the weight that should be attached to private life, which is established while the person's in the UK. And you have my submission as to why. Firstly, Rupia allows a certain amount of leeway. Section 117. B, 4 and 5 aren't intended to impose straitjackets, and we say that the tribunal gave sufficient reasons for attaching some weight, not determinative weight, but some weight to the private life established here and to the strength of connections to the length of time in the UK. On the section 117B3 point, that's the financial independence point, I accept that was a matter which was before the First-tier Tribunal. I accept that the First-tier Tribunal didn't deal with it expressly. My submission is that it was obvious to the First-tier Tribunal that the appellant was not financially independent. We know that from the fact that he was in prison. He's been in prison for a large amount of for a large proportion of the 5 or 6 years before the tribunal hearing. We know it from the fact that his own account is that he was in drug debt, and that was why he was offending. And we know it from the account, and I'm sorry, I've said this already, but we know it from the account of his living circumstances, that he was living on the floor in a room. He'd been living on the floor in a room where his dad had a single bed. So the First-tier Tribunal can have had no doubt about the fact that the appellant lacked financial independence. The question is simply whether the failure expressly to record that and expressly to treat that as a factor adverse to his claim is a material error of law. My submission is that it isn't, because it should be clear from the determination that would not have caused the First-tier Tribunal to reach a different conclusion. But that's how I have to put the case on that. I do accept that the matter wasn't considered and that it wasn't taken into account. And of course I do accept that it's a mandatory consideration. I have to make the submission, I do make the submission, that in circumstances where there was no dispute about financial independence, where the tribunal must have been aware of the lack of it, that the failure to record that and refer to it specifically in reasoning is not fatal. My lords, can I just check? Lords, unless I have anything else, thank
Ground
you for your
two,
patience.
you're dealing with just the submissions you made.
Ground two, we have the oral submissions, the written submissions, but I have to say that if this appeal were to turn on ground two, I might be in some difficulty for the reasons.
So what you say is that even if they establish ground two, it doesn't make a difference.
Doesn't make any
because
difference.
even
They've
if
either
the
won or
tribunal
they've
had done
lost.
its job, it would have had to say there was no error.
Well, so we say on our case.
That's your submission.
Our submission is that if my learned friend succeeds on ground one, then
It's different.
again it doesn't.
Yeah.
Well, if
Right.
my learned friend succeeds on ground one, it doesn't matter either, because you'll find that the First-tier Tribunal material erred in law and the Upper
Then it
Tribunal
would be a
is
matter for
wrong.
us to decide whether we want to go on to deal with ground two or not.
That's what my lord. Yes, that's
Thank you.
right. Just on the final point about where it should be remitted to, the one consideration, if you're remitting to the First-tier Tribunal, the presumption would be that it would be for full rehearing. If you're remitting to the Upper Tribunal, I'd invite you to record that the facts are unchallenged and to preserve the facts that were found. They're not disputed. The facts that are found in the First-tier Tribunal's previous determination.
Right.
And to treat those as starting one. That would be a basis on which the matter should continue in the Upper Tribunal, because that would reduce the number of facts that need to be found.
Thank you.
My lords, thank you for your patience.
Yes, not at all. Mr. Skinner.
My lord, I'm conscious that this is very much the graveyard slot of these 2 days, and I'll be as brief as I possibly can. Just to pick up the point that my learned friend made at the end about preserving facts. On the facts of these, in this appeal, I don't think that's possible, because time has moved on. As my learned friend said, there would need to be an up-to-date assessment of the mental health position, etc., etc. The job of the
So you would say full rehearing?
whether it's in the Upper Tribunal
Yes.
or in the First-tier Tribunal,
Okay,
it's got to
thank
be a
you.
full rehearing.
Yes.
Just while I'm on the remake or remit question, as the Upper Tribunal would put it, I'm reminded that my Lord Justice Stuart-Smith considered in the AAB case the Upper Tribunal's practice statement in relation to whether to remake or remit. I gave an explanation earlier about the practice, but that's where that practice is codified, for want of a better word. It exists and it's cited in that. That case is the first tab of the supplementary authorities bundle
Thank
that was
you.
handed up yesterday. There's nothing from the
No.
reasoning in the case that's relevant to this, but just so that you're aware that the way in which the tribunal approaches it is set out in that practice.
Yes.
I think it's a practice statement.
Yes.
It was said that the grounds of appeal didn't include the points about the relationship with the son. The Secretary of State doesn't accept that. I'm not going to take the portrait at this
Are
point.
the
in the afternoon.
grounds in the bundle?
They are.
If you give us the page number, we'll be able to read them for ourselves.
Exactly, that's what I propose to do. It's paragraph 8 on page 82 of the core bundle. That's where I say the grounds contain at least sufficient kernel, as it were, of the point for it to be there. And even if I'm wrong about that, and the grounds didn't contain sufficient to make it an issue, it's clear that the Upper Tribunal accepted that it was an issue and proceeded on the basis of the issue.
What was an issue?
The question of whether or not the First-tier Tribunal had adopted the proper approach in relation to the appellant and his son.
Right.
And I took you earlier to paragraphs 11 and 14 to 15 of the Upper Tribunal's decision. And so to the extent that it wasn't in the grounds, it was obviously something which the Tribunal permitted to be argued. And in those circumstances, it's not a case where this is a new point before the Court of Appeal. It was before the Tribunal.
If you say it's in paragraph 8 when it said there were no reasons over and above unduly harsh consequences, given the lack of contact with the son.
Exactly. I appreciate that that's very shortly expressed, but in my submission, that's sufficient. Can I just deal with the point that was made about the focus being on the father in relation to the impact of the potential relationship, and the submission that was made that that sort of obviates the need to make some form of best interests assessment? In my submission, that's wrong in principle, and it's wrong in principle because there might be circumstances where a father or any parent is deeply troubled by the lack of their relationship with their child, but it is not in that child's best interests to have that relationship. And so in my submission, it's not adequate to forget about the best interest of the child and just focus on the father. You have to, if you're going to focus on the father, you also have to consider the best interest of the child. My learned friend made points about the decision in Yeltsin and this court's subsequent treatment of them in Capicania and Majera. I think it's important just to underline the effect of my learned friend's submissions is that effectively this court should be asked to depart from the approaches in Capicania and Majera on the basis that effectively Yeltsin is binding and they are not. I think it's just important for the court to, if it's going to do that, to be sort of open-eyed about what it's being asked to do.
Sorry, I'm not following that. There's the question of the test, which is compelling circumstances over and above exceptions 1 and 2. That is the test. Yeltsin is how do you determine whether or not that test is applied? And that says good practice, start with exceptions, identify it, may not always be possible, and in any event, there's no rule of law. That's the position, isn't it?
I'm not going to repeat Mr. Malik's submissions. I'm not going to concede points that he's made. But as I understood Mr. Malik's submissions, that it is a point of law that it is a legal requirement that.
Oh, I see that you've got to do it. Okay, yes, right.
And
I'm sorry. Yeah.
And as I understood Mr. Malik's submissions, they were that principle was taken from Capicania and Majera.
Yes. So we have to decide what Capicania and Majera decide.
Quite.
So it is binding to follow exception 1, and that's what Majera and Kappa, I think, they've all decide. Okay, and is that correct? Yeah.
Yeah. And then just finally, I thought it might be helpful just to identify what I perceive to be quite a large degree of common ground between the parties as to the appropriate approach in Article 8 in the Section 117C6 cases. I entirely agree with the observation that Your Lordship, Lord Justice Lewis, made earlier, that labels in this context are perhaps unhelpful and quite difficult. But I think there is a commonality between the Secretary of State and my learned friends as to both the labels and I think what they actually mean in practice. So I think, as I understand it, it's common ground that Section 117C6 requires what the Supreme Court has described as a full proportionality assessment, that involves taking into account all relevant factors and ultimately balancing the two sides of the scale, that in doing that, weight has to be given to the national authorities, and that in this context, at the very least, that means that weight has to be given to the public interest that deportation is required in respect of foreign national offenders, unless one of the exceptions is met or there are very compelling circumstances over and above. That means that the weight prescribed by statute under the exceptions and under Section 117B is relevant to and to be ascribed to the various factors in the assessment. And we both agree that there is a degree of flexibility. I think we might disagree about the extent of that flexibility, but we both agree that there is a degree of flexibility on both sides of the coin. So my learned friend says there's no straitjacket. Well, I think that's probably right, but there's also no sort of roaming free. This isn't, there's no complete freedom.
When Parliament says there's a public interest in deportation, if we think he's a reformed character and will probably go straight, we can say no. Public interest isn't.
No, so on the question and the debate that Your Lordship had with my learned friend about the lowering of the public interest, I think I would put it this way, that the public interest in deportation can be lowered, but it can't be lowered beyond the point that it requires deportation. It's always above that threshold, because that's what the statute says. It can't be lower than requiring deportation. But in terms of how much it requires deportation, that will depend on the starting point of how serious the offending is, and then taking into account rehabilitation, etc., you might get it down a bit, but you're never. There's a flaw, which is the statutory flaw that deportation requires.
Public interest.
Sorry, the public interest requires deportation.
Yes.
Where I think we don't agree, or one of the issues on which we don't agree, is whether the factors in the exceptions are matters to which weight has to be given if the exceptions don't apply for the purposes of 117C6. You've had my submissions and my own friend's submissions. We say they are relevant in that assessment. He says once the exceptions aren't met, you sort of leave those behind and you conduct.
So no, I don't think he did say that. No,
in which case I've misunderstood.
No, he didn't say that.
Okay, well in which case...
I think you agree on that.
Right.
But the fact that you aren't within exceptions 1 or 2 doesn't mean that factors that would be taken into account if exceptions 1 or 2 did apply are not relevant, or they remain relevant.
Fine. Well, in which case, I'm grateful to that clarification and that I haven't misled you into understanding there's a dispute when there isn't one. My learned friend gave one example in relation to a potential foreign adoption. I just want to express a note of caution about that case because I think it's a pre-2014 Act Amendments case and it would need to be seen in the light of the developments. And I'm also conscious of the relatively recent decision about family life with those abroad in I appreciate it's a different context to Gaza case. I'm not saying that it's not relevant, but I just want to express a degree of caution about that and leave that for a case in which that issue arises.
Thank you.
Unless I can assist your lordships, I think that is everything I need to say in reply.
My lords, I know I don't have a right to reply to a reply, but just because this is I'm very grateful for the common ground, but I think I'd just like to also put down a marker that I said that require. I don't agree that the word so my submission was that require has to be read purposefully, just as automatic does. An automatic deportation is automatic unless it's not automatic. Deportation is required unless it's not required, according to both the statutory frameworks and the 2 acts. So I would not like to adopt the common ground on required. Other than that, I completely agree with something.
Thank you. Anyone else? No. You've been extremely patient with us, with peppering you with questions. So thank you very much for your respective submissions. We will, of course, be reserving our judgments. You will receive in draft for the usual very limited purposes, which you must adhere to. And we would assume that you'll be able to agree the draft order, but if there's anything outstanding, we'll deal with it on paper. Thank you all very much.